Ms. Fiore and Ms. Corrigan, it looks like you have both made it into the virtual courtroom. Welcome. We are ready, Ms. Fiore, when you are.
Thank you. Good morning, Your Honors. May it please the court, Kristen Fiore of Ackerman here today on behalf of Appellant SLG LSI Investment, LLC. I would like to reserve 5 minutes for rebuttal, please.
Very good.
Your Honors, the trial court's denial of the motion to compel arbitration in this case is contrary to binding case law, the arbitration agreement's clear terms, and the strong public policy favoring arbitration. All of Mr. Capilla's claims in this case are subject to arbitration. The amended complaint makes two basic overarching claims. One is that the board fraudulently distributed dividends, and then after doing so, altered Holdco's operating agreements to insulate itself from any liability resulting from those fraudulent dividends. Both of those allegations implicate Holdco's operating agreement, as the facts giving rise to them could not have occurred without that operating agreement. This alone demonstrates the arbitrability of this case. Now, Mr. Capilla makes the argument heavily in his answer brief that the 2017 agreement containing the arbitration clause was not in effect at the time that the distribution of the dividends happened. That's irrelevant. This court's 2018 Johnson case is binding on that issue. Johnson holds that the quote controversy, unquote, which is what we have, that's the language we have in the arbitration provision here, arises for arbitration purposes when the lawsuit is filed, not when the injury occurs and not when the cause of action accrues. However, arbitration is still required even if this court determines that the operating agreement in effect at the time of the alleged improper conduct governs arbitrability. If you look, I'd ask you to look carefully at the allegations of the amended complaint, starting on page 106 of our appendix. And you'll see that Mr. Capilla's allegations are not limited to facts occurring in 2015. In fact, he explicitly alleges misconduct occurring, and if you'll permit me to read from the amended complaint very briefly, he says, as part and parcel of the fraudulent transfers made to the defendant, the following constitutes a non-exhaustive list of the acts and/or omission by the company's management that constituted a breach of their fiduciary duty, and this is the key here for the timing question, quote, from and after July 2015 through the filing of the LSI assignment case, which the amended complaint goes on to define as the date Mr. Capilla received the assignment on behalf of creditors in that case. That was March 2019. So the explicit allegations of the amended complaint, which have been incorporated through the entire complaint, cover a period of time from July 2015 when the dividend distributions occurred to March 2019, clearly covering the 2017 agreement with the arbitration provision in it. In addition, the amended complaint alleges that, as I just said, that the 2017 agreement itself, even though it doesn't use the name, and Mr. Capilla says, well, you know, I don't use the words 2017 third restated operating agreement in my complaint, but he still alleges, if you look at page 107 of the appendix, that as part of these acts and omissions that occurred as, quote, part and parcel of the fraudulent transfers, that the management of Holdco attempted, quote, to release and insulate, exonerate management from any liability in connection therewith. Well, the way in which Mr. Capilla alleges they did that was through the creation of first the second operating agreement, which had the same arbitration provision as the 2017 agreement, and then carried on their alleged, for lack of a better word, cover up of their improper distributions by then creating this other agreement with provisions to insulate themselves from liability. We also maintain that this court and the trial court did not need to, and we argue this in our briefs, did not even need to reach the question of arbitrability in the first instance, because the arbitration provision, by its clear terms, delegates that question to the arbitrators themselves. It says that any, after the language concerning the arising out of or relating to, and any dispute as to whether a particular controversy is subject to arbitration.
Doesn't the trial court first have both the right and the obligation to determine whether or not the parties are in fact subject to the arbitration agreement, whether or not there is an arbitration agreement that applies between the parties?
So I think the question is, when you have a clear, the case law says when you have a clear delegation clause, like we do in this case, that the court, unless there is an explicit, and this is the Parnell case from the in the federal court, which is citing Rent-A-Center, and it's cited in our briefs, unless there is a challenge to the validity of the delegation provision in a vacuum, then it goes to the arbitrator. So if there, and there is really
any party, or let me rephrase it, anyone who is not a party to the arbitration agreement and who contends they're not bound by the arbitration agreement, your position is that goes to arbitration.
Correct. With an express delegation.
I understood, because I don't agree with that, but I wanted to make sure I understood that's your position.
Well, in this case, I would argue that, so they do, that kind of leads into their argument that LSI management is not a party to this arbitration agreement, and because they didn't sign Holdco's operating agreement. But if you look at, there's a case from the 3rd District, the Aiken Bay case, it's cited in our briefs. It's also a fraudulent transfer case. What happens is, and you probably already know this, but when you have these cases under Chapter 727, which is an assignment for the benefit of creditors case, the assignee steps into the shoes of the assignor for the purposes of the governing agreement, right? So here, Mr. Capilla stepped into the shoes of both Holdco and LSI management. He takes great pains to say that LSI management was really not subject to Holdco's operating agreement. However, the own allegations of his complaint indicate that the two cannot be separated for these purposes. If you look at pages 113 through about 117 of our appendix to the initial brief, the amended complaint explains LSI management is a wholly owned subsidiary of Holdco, and the agreement makes clear that purposes of Holdco include borrowing money, refinancing, et cetera, which includes making these distributions directly or indirectly through one or more of its subsidiaries, which was LSI management in this case. And if you want to see the provision in the Holdco agreement that governs that, that's at page 173 of the appendix. So I understand your question, and I think that generally, yes, but in this case, there is a clear delegation provision. And although they argue that the validity of the arbitration provision itself is in question, I don't think that's really what they're arguing. But that would be my answer to that. And if there's no further questions right now, I'll reserve the rest of my time for rebuttal.
You'll have the 5 minutes for rebuttal, Ms. Corrigan. Don't forget to take off the mute.
May it please the court, I'm Jody Corrigan with the law firm of Rock, McLean, and Sabar, representing the appellee, Sonique Capilla. The trial court correctly denied the motion to compel arbitration, and this court should affirm. The statutory fraudulent transfer claims that are alleged in the amended complaint do not arise out of or relate to any agreement, let alone the agreement that has the arbitration provision. The claims arise from duties imposed by statute, irrespective of any agreement. The amended complaint does not in any way invoke or rely upon the language of the third restated LLC agreement, which is the agreement that they say has the arbitration provision that should control this matter. Candidly, the Verizon Wireless case that this court decided in 2019, as well as the Florida Supreme Court case in Seifert, which is cited in all the briefs, are dispositive here. The facts of this case, I disagree that the appellant has characterized the amended complaint as bringing in the language of the third amended restated LLC agreement. It's simply not true. Yes, it is not stated in there at all. It is not attached to the complaint, but we're not arguing about the applicability of that agreement anywhere.
It is referenced in the complaint, though, correct?
No, actually, the third restated agreement is not referenced in the complaint. We do talk about a restructuring of the companies, but that actually happened before the third restated LLC agreement. The part where it was discussed.
Remind me, what I don't have it right in front of me. The arbitration provision was included where?
They filed the motion to compel arbitration.
So where in the documentation was the arbitration agreement incorporated?
It's in our response to the motion to compel arbitration.
I'm not being very clear. What document created the arbitration agreement?
Oh, the third restated LLC agreement.
And you did not sue on the third.
Correct.
But you outlined the sequence of events up to the date of the transfers, if I recall correctly.
Right.
Okay.
And we did discuss the third restated LLC agreement in our response to the motion to compel arbitration. And that's in the appendix at pages 225 to 226. We need to keep in mind what the facts are here. The appellee, Capilla, is the statutory assignee for the benefit of creditors, and it's his job to recover any fraudulently transferred assets for the benefit of creditors, which include almost 600 employees who lost their jobs. In July of 2015, the Board of Managers took out, in spite of the fact that they knew that there was a huge verdict against them, multi-million-dollar, they took out a $150 million loan and they distributed the proceeds, approximately $110 million of that loan, to themselves and equity owners. The amended complaint alleges 6 statutory claims for avoidance and recovery of that money, of those fraudulent transfers under Florida and Delaware law. There is no breach of contract claim. There is no claim relating to the contract at all. There's no fraud claim other than the statutory fraudulent transfer claims. We do acknowledge that LSI was not a party to any agreement with an arbitration provision, and it's a Florida company, Holdco, and SLG or Delaware company. So we've asserted the claims under Delaware and Florida law. If you look at what's required to prove a fraudulent transfer claim, we've alleged claims for constructive fraud and actual fraud. For constructive fraud, you have to prove the debtor did not receive reasonably equivalent value in exchange for the transfer. The creditor's claim arose before the transfer was made, and the debtor was insolvent at the time of the transfer or became insolvent as a result of the transfer. To prove actual fraud, you have to prove that the transfers were made with an actual intent to hinder, delay, or defraud a creditor. Here, the plaintiff must prove that there was a creditor, there was a transfer of property, and that the debtor had the intent to hinder, delay, or defraud a creditor, which can be shown by the badges of fraud that are part of the statutes. The elements necessary to prove a fraudulent transfer claim do not rely on any contract at all. And this is the case, as I mentioned, the Verizon Wireless case. There had been a cell service agreement. The customer ended up filing for bankruptcy, and the debt owed under the wireless agreement was actually discharged in bankruptcy. But after the time of the discharge, Verizon sent a demand letter. So the plaintiff turned around and filed a lawsuit under the state and federal laws for fair debt collection practices, saying you can't sue me, the debt was discharged. And Verizon argued, well, there's an arbitration provision in the customer agreement, and this must go to arbitration. And the court specifically rejected that because the claims were separate and independent from the agreement itself. So in this case, when you're looking at whether
one other question on that. I'm not sure. Are you hearing a bad echo?
I am not.
Okay, let's see if it goes away. I'm hearing it, but it seems to have dissipated. Could a lawsuit have been brought based on the distributions being inconsistent with the operating agreement or the management agreement?
Could it have been brought? Candidly, I have not looked at that, whether it could have been brought for violating the operating agreement. At this point, the process was for Mr. Capella to try to retrieve any and avoid any fraudulent transfer. So whether it was under the operating agreement or not, it's not necessary. It's not a part of the fraudulent transfer.
This is a statutory cause of action that's being brought.
Right.
But it does strike me that if the operating agreement and management agreement and related documents within the entity outline how monies are to be handled and when partners or managers and members are going to get repaid any loans they had made, any investment they had made, how they're going to handle distribution of finances, that in theory would be something that could be brought under the agreement.
In theory, I'm still not sure because of the fact that the fraudulent transfer statutes are pretty specific about what you need to
your position, I'm assuming what your position is that whether they could have been brought through a different vehicle, that's not the vehicle that your client either chose or was obligated to pursue.
Absolutely. That is not the position that was taken. And candidly, at the time, the agreement that was in effect, if we were to be governed under any operating agreement, the agreement that was in effect at the time of the distributions did not have an arbitration provision at all.
But
So
there is case law that supports a subsequently adopted arbitration provision can apply to
yes.
earlier acts.
Yes, but let me address that, and I'll address the Johnson case as well. Johnson was the nursing home case where the nursing home patient had sustained injuries, and then there was a later arbitration agreement between the nursing home and I believe her son signed as her agent. And when she filed suit, and this is the case that the appellants have argued, is that it was the filing of the lawsuit itself that was the controversy, not the fact that she was injured. And this case is different, and I'll tell you why, because the arbitration provision in Johnson required arbitration of any dispute between the parties. The arbitration agreement that they're relying upon in this case does not. The arbitration is more limited, and it doesn't apply to any dispute or controversy between the parties. It applies only to any controversy, specifically, it says, arising out of or relating to this agreement. It doesn't say any dispute between the parties. So that is a distinction. It's not the same type of arbitration agreement. So this is not one where a later arbitration agreement reaches back. I believe we cited the case in our brief, the Peerless Importers case, where it talks about an arbitration clause in a new agreement does not reach back retroactively to cover disputes that arose before the agreement unless the parties make it clear that such a pre-existing dispute was within the scope of the clause. So you would have to have some type of language in there, and it could have easily done so. It could have said, any dispute arising out of or relating to this agreement or any prior agreement. But then again, we also go back to whether a statutory fraudulent transfer claim is a dispute that arises under or relates to the agreement, when you don't need proof of the agreement in order to prove the claim.
What if the defense wants to bring in the agreement to establish that the transfers were authorized under the agreement? Does that change the analysis?
I don't believe it does. It's still not an element of proof to go through and explain what the agreement required. The elements of proof are required to show whether there was a creditor at the time, whether they knew there was a creditor at the time, whether they disposed of the assets of the company resulting in insolvency. That's a fraudulent transfer.
So whether the operating agreement or management agreement would authorize such transfers as part of the ordinary course of business, in your estimation, is irrelevant to whether or not it's a fraudulent transfer?
Yes, I believe it is irrelevant because certainly it could not be in the ordinary course of business when they basically took all the assets. And this is what goes back to the fraudulent transfer. They took all the assets of the corporation, knowing there was this huge liability sitting out there, and transferred it not to somewhere else, but to themselves and to other insiders. This is the core of a fraudulent transfer claim, and it really does not relate to the agreement. Because I think even if the agreement permitted such a thing, it still would be separate and apart from a fraudulent transfer. It simply stands on its own. And if we go through the case law on whether a parties agreed to arbitrate something, the Seaford case, the Verizon Wireless case, all state that if you're dealing with an arbitration clause that talks about arising out of or relating to an agreement, there has to be the contractual nexus or significant relationship between the disputed claims and the agreement. The mere fact that a dispute wouldn't have arisen but for the existence of the agreement is not enough, or the fact that the agreement created the relationship of the parties is insufficient. It does not render it as something arising out of or relating to the agreement. You have to have, in this case, there is no nexus because the duty allegedly breached is under the fraudulent transfer statute. It's something that arises separate and apart from any contract at all.
Well, let me ask you a question on acquiescence. They allege acquiescence. If acquiescence occurred, then the issue of arbitrability and whether the agreement applied really would be moot, correct?
It would be, but there was no acquiescence in this case. What happened was the lawsuit was filed. They moved to compel arbitration. Mr. Capilla amended the complaint and they moved to file arbitration again. And then we disputed the arbitration. The court held a hearing and determined that this is not something that fell within the scope of the arbitration provision. So I don't believe that there was any acquiescence in this case. And back to the fraudulent transfer cases, that we cited a number in our answer brief, a number of cases that all talked about the fact that a fraudulent transfer case does not arise from the contract. There was a case that they had cited, the Aiken Bay case, where the court concluded it did arise from the specific contract, but we cited a number of cases that showed why fraudulent transfer cases are generally not arising from contract. We cited the Cannon Latin America case, which was a Southern District of Florida case, which held that a Florida fraudulent transfer claim did not arise from the contract. We cited the Dooley case, which was Arizona, and basically stated that a duty imposed under the Fraudulent Transfer Act did not require enforcement of a contract, and therefore the fundamental nature of a fraudulent transfer action is one that does not arise from contract. We cited, I don't need to go through all of them, they're all cited in our brief, but there's a number of cases that have all held that a fraudulent transfer claim is separate and apart from a contract, and therefore it stands alone. I also think it's important, the timing we already discussed, that the fact that this is different from Johnson. So here, the controversy when it arose, this is not an arbitration provision that was reaching back. That was also in the Clay case, which was an 11th Circuit case. And to the argument that the arbitrability should have been decided by an arbitrator and not the court, we cited the cases again in our appellate brief. The 360 campaign consulting case basically said that substantive arbitrability is an issue for judicial determination only unless the parties clearly and unmistakably provide otherwise. So the question of whether it should be arbitrated is left to the arbitrators only when the arbitration clause provides for arbitration of all disputes. We've already discussed the fact that this arbitration clause does not provide for arbitration of all disputes. In fact, we cited it in our brief, but there are other provisions of the contract. There's an indemnity provision, there's a tax election dispute, an informed consent provision. There are other sections of the third restated agreement that do not require arbitration of the dispute. So this is not as broad as a case that would require any dispute between the parties. I think that the court should affirm, based on the fact that the trial court correctly looked at the arbitration agreement and looked at the claims as alleged. The claims that alleged do not rely in any manner on the actual language of any operating agreement, let alone the operating agreement that was enacted after the fact.
Very good. Thank you very much. Ms. Corrigan, Ms. Fiore.
Hi. Okay. I just want to touch briefly in the limited time that I have left. It's impossible to separate the causes of action they're making in this case from the factual allegations of the amended complaint. I direct you to the Gregory case cited in our brief from the 11th Circuit that says whether a claim falls within the scope of an arbitration clause turns on the factual allegations of the complaint and not the legal causes of action. Statutory causes of action are arbitrated all the time with agreements like this, as is shown in the case law we cited. And there was a question, I believe, from Judge Silberman of Ms. Corrigan that, does the amended complaint reference explicitly the third agreement? While it doesn't, it certainly references on page 122 of our appendix the second restated agreement that the members of Holdco executed that agreement. That agreement on page 383 of our appendix has the same exact arbitration provision at issue in the third agreement. So the fact that they didn't explicitly name the third agreement does not allow them to escape from the ambit of the arbitration provision. There was a mention of Seifert and the Florida Supreme Court case, and I would submit that this case is not inconsistent with Seifert. That case is factually distinguishable. I'll direct the court to the Jackson case that Mr. Capilla cites, which it's also a Florida Supreme Court case, more recent, that interprets Seifert. And in that case, they discuss that, yes, there's this contractual nexus thing and it has to have a significant relationship to. However, if it implicates legal duties arising under the agreement, then there's a sufficient nexus. So in this case, and I believe Judge Silverman was getting to this in some of his questioning, if we want to argue that, at some point as a defense that our Holdco wants to argue that they were acting consistently with their requirements under their operating agreement, then naturally that is going to fall within their legal duties under a contract and their management legal duties, their managers and their members. And then Judge Valenti, you asked a question about acquiescence, and that's adequately addressed in our briefs. However, an important point that we make in the argument regarding the delegation clause is, if you look at that Parnell case and the Rent-A-Center cases from the 11th Circuit, they require that if you're going to challenge the applicability of a delegation clause, that has to be pled in your complaint. And so at a minimum, we would argue that there's acquiescence as to the application of that portion of the arbitration provision. And if there are no further questions, we would ask this court to send this case to arbitration consistent with binding case law, the parties' agreement, and the strong public policy in favor of arbitration. Thank you.
Very good. Thank you both for the presentation. That concludes the oral argument portion of our docket. We are adjourned.